This video is only for remembering keywords, not for understanding the topic from scratch. It's meant for students who already know the concept. If you find a mistake, let me know.
Relation of partners to one another. 1. General duties of partners. Carry business on the greatest common advantage. Render full information to partner or legal representative. Utmost good faith in dealings. Render accounts to each other. If kept by one person, he will be prima facie a proper person to explain full information. 2. Duty to indemnify for loss caused by fraud. Partner committing fraud must make good the loss sustained by his misconduct. Amount so brought will be divided between partners. If fraud on his co-partners, that is cheating, co-partners can throw whole consequences upon him. 3. Rights and duties of partners. Subject to the provisions of this Act, it is determined by contract which can be express or implied. It is varied by consent of all the partners which may be express or implied. Agreement in restraint of trade, a partner shall not carry on any business other than that of the firm while he is a partner. 4. Conduct of the business. Subject to contract. Partners. A. Right to take part in the conduct of business as partnership. Business is a business of the partners and their management powers are generally coextensive. B. Bound to attend diligently to his duties. C. Right to be consulted in case of differences. Ordinary matters are determined by majority. Change in the nature of business requires consent of all the partners. Note: majority must be exercised in good faith and every partner must be consulted. D. Every partner, whether active or sleeping, is entitled to access, inspect, and take copy of books of accounts in good faith. E. Right of legal representative, heir, or agent. In the event of death of partner, they can access, inspect, and take copies of books of accounts. 5. Mutual rights and duties. Subject to contract between the partners. A. Remuneration. No remuneration for taking part in business subject to express agreement or dealings. But, if customary to pay remuneration, partner can claim it even without agreement. B. Profit and loss. Right to share profits and loss equally. If agreement made, it will prevail. Also, there is no connection between profit-sharing ratio and capital contribution. C. Interest on capital. Following elements required for interest on capital: express agreement or practice of partnership, trade custom, and statutory provision by law. D. Interest on advances. Partner is entitled to claim interest at 6% per annum on amount paid in addition to capital contribution. It will keep running even after dissolution and up to date of payment. E. Right to be indemnified. Every partner has the right to be indemnified in respect of payments made and liabilities incurred in ordinary conduct of business and emergency, for protecting the firm from any loss as a man of ordinary prudence would make in his own case under similar circumstances. F. Right to indemnify the firm. Partner must indemnify for any loss caused to it by willful neglect in the conduct of the business of the firm. Partnership property / partnership assets / joint stock / common stock / joint estate. The property which is deemed as belonging to the firm in the absence of any contract. A. All property, rights, and interests which partners may have brought into the common stock as their contribution to the common business. B. All the property, rights, and interest acquired or purchased by or for the firm in the course of business. C. Goodwill of the business. Property of a partner. Where a property exclusively belongs to a person, it does not become a property of the firm merely because it is used for business of partnership unless there is an agreement. Note: whether it is property of firm or not will depend upon the real intention of partners. Partners may by agreement convert exclusive property into a partnership property. About goodwill. It is the value of reputation of a business house in respect of profits expected in future over and above the normal level of profits. Partnership firm is dissolved. Every partner has a right to have the goodwill of business sold, and it can be sold separately or along with the other properties of the firm. Agreement in restraint of trade in case of sale of goodwill is valid if the restrictions imposed are reasonable. Application of property of the firm. Property of the firm shall be held and used exclusively for the purpose of the firm. In partnership, there is a community of interest which all the partners take in the property. Partner doesn't have any proprietary interest in the assets of the firm. Every partner of the firm has a right to see that all the assets of the partnership are applied to and used for the purpose of partnership business. Personal profit earned by partners. If a partner derives any profit for himself from any transaction of the firm, or from the use of the property or business connection of firm or the firm name, he shall account for that profit and pay it to firm, subject to contract. If a partner carries on any business of the same nature as competing with that of the firm, he shall account for and pay to the firm all profits made by him in that business. Relation of partners to third parties. 1. Partner to be an agent of firm. A partner is the agent of the firm for the purpose of business of the firm. Partner embraces character of both principal and agent. Acts of himself in the common concern, hence deemed principal, and acts for partners, properly be deemed as agent. Partner is an agent only for the purpose of business of the firm. 2. Implied authority of partner as agent of the firm. Act of a partner which is done to carry on in the usual way, binds the firm. Authority to bind the firm is called implied authority. In the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower. Bad water. Open a banking account on behalf of the firm in his own name. Acquire immovable property on behalf of the firm. Submit a dispute relating to the business to arbitration. Withdraw a suit or proceedings filed on behalf of the firm. Admit any liability in a suit or proceedings against the firm. Transfer immovable property belonging to the firm. Enter into partnership on behalf of the firm. Compromise or relinquish any claim or portion of a claim by the firm. Mode of doing act to bind the firm. In order to bind a firm, the act or instrument executed should be executed in the firm name with an intention to bind the firm. Such an authority is called implied authority. Implied authority have following restrictions. A. Act done must relate to the usual business of the firm and within the scope of authority and relate to normal business of firm. B. Act is done for normal conduct of business, which will depend upon nature and circumstances of each particular case. C. Act to be done in the name of the firm or in any other manner with an intention to bind the firm either in express or implied way. 3. Extension and restriction of partners' implied authority. Implied authority of a partner may be extended or restricted by a contract between the partners. Restrictions imposed on the implied authority of a partner by agreement shall be effective against a third party. When third party knows about the restrictions, then he can't make the firm liable on it. When third party does not know that he is dealing with a partner in a firm, then he can make the firm liable on it. Note: any one partner or even a majority of the partners cannot restrict or extend the implied authority. Consent of all partners is required for the restriction. 4. Partner's authority in an emergency. Partner has authority in an emergency to do all such acts for the purpose of protecting the firm from loss as would be done by a person of ordinary prudence, in his own case, acting under similar circumstances, and such acts bind the firm. Effect of admissions by a partner. Partners, as agents, can make binding admissions, but only in relation to partnership transactions and in the ordinary course of business. Admission or representation will not bind the firm if the authority is limited and other party knows about it. Effect of notice to acting partner. The notice to a partner who habitually acts in business of the firm, relating to affairs of the firm, operates as a notice to the firm. Notice to one is equivalent to notice to all, just as a notice to an agent is notice to his principal. Exception: fraud, committed by or with the consent of that partner. Notice must be actual and not constructive. Must be received by a working partner and not by a sleeping partner. Notice must relate to firm's business, then only it will constitute notice to firm. Liability to third parties. 1. Liability of partner for acts of the firm. Partners are jointly and severally liable for all acts which comes under the scope of their express or implied authority, because acts done within the scope of authority are the acts is done towards business of firm. Act means rights enforceable by or against the firm. Act to be enforceable must have been done while he was a partner, it being immaterial that the damages arose after the dissolution of the firm. 2. Liability of firm for wrongful acts of partner. Firm is liable to the same extent as partner for any loss or injury caused to third party by the wrongful act of partner done in the ordinary course of business and within authority of partner. Method employed by partner in doing wrongful or unauthorized act would not affect the question. All partners liable to third party for loss or injury caused to him by the act of any partner acting in ordinary course of business. 3. Liability of firm for misapplication by partner. If partner acts within his authority and receives money or property belonging to third party and misapplies it, not necessary that money should come in its custody, Or, if money or property comes into the custody of firm and misapplied by any partner, the firm will be liable in both the cases. If receipt was not in authority of partner, it can't be said that money received by firm. Hence, firm not liable unless money comes into firm's custody or control. Rights of transferee of a partner's interest. A share in a partnership is transferable like any other property. But as the partnership relationship is based on mutual confidence, the assignee of a partner's interest by sale, mortgage, or otherwise cannot enjoy the same rights and privileges as the original partner. During the continuance of partnership, such transferee is not entitled to interfere with the conduct of the business, to require accounts, or to inspect books of the firm. He is only entitled to receive share of profit, and he is bound to accept it, cannot challenge it. On dissolution of firm or retirement of transferring partner, transferee is entitled to receive the share of assets of firm to which transferring partner was entitled. For the purpose of ascertaining share, entitled to accounts as from the date of the dissolution. Note: partner can transfer its share, but only after approval from all partners. At the same time, a partner is not debarred from transferring his interest. Minor cannot be bound by contract because a minor's contract is void. Minor can't become partner in partnership firm as he is incompetent to contract, but he can be admitted to the benefits of partnership with the consent of all partners under rights of a minor. A. Minor has right to his agreed share of profits. B. He can have access, inspect and copy of accounts of the firm. C. He can sue the partners for accounts or for payment of his share, but only when he is severing his connection with the firm and not otherwise. D. On majority, he may within 6 months elect to become a partner or not to become a partner. If he elect to become a partner, he is entitled to share as earlier. If does not, his share is not liable for any act of firm after public notice. Liabilities of a minor partner. Before attaining majority, A. The liability of the minor is confined only to the extent of his share in the profits and the property of the firm. B. Minor has no personal liability for the debts of the firm incurred during his minority. C. Minor cannot be declared insolvent, but if the firm is declared insolvent, his share in the firm vests in the official receiver/assignee. 2. Liabilities of a minor partner after attaining majority. Within 6 months of attaining majority, or after obtaining knowledge that he had been admitted to the benefits of partnership, whichever date is later. Decide whether to remain partner or leave the firm. I. When he becomes partner. If minor became partner willfully or failure to give public notice within 6 months. A. He becomes personally liable to third parties for all acts of firm since he was admitted to the benefits of partnership. And B. His share in the property and profits remains same as earlier. 2. Where he elects not to become partner. A. His rights and liabilities continue as minor up to date of public notice. B. His share shall not be liable for any acts of firm after date of public notice. C. He is entitled to sue the partners for his shares. Minor must give notice to registrar that he has or has not become partner. Note: where he elects not to become partner or failure to give public notice within 6 months, he shall become a partner at the expiry of 6 months. Legal consequences of partner coming in and going out. Any change in admission, retirement, expulsion, insolvency, etc. in relationship of partner will result in reconstitution of firm. 1. Introduction of a partner. No new partners can be introduced into a firm without the consent of all existing partners. Rights and liabilities of new partner. Liabilities ordinarily commence from the date when he is admitted, unless he agrees to be liable for obligations incurred by the firm prior to the date. The new firm may agree to assume liability for the existing debts of the old firm, and creditors may agree to accept the new firm as their debtor and discharge the old partners. The creditor's consent is necessary in every case to make the transaction operative. Novation is the technical term in a contract for substituted liability. But a mere agreement amongst partners cannot operate as novation. Thus, agreement between partners and incoming partner that he shall be liable for existing debts will not give creditors any right against incoming partner. 2. Retirement of a partner. A partner may retire. 1. With the consent of all other partners. 2. By express agreement. 3. By giving notice in writing to all other partners of his intention to retire in case of partnership at will. Retiring partner may be discharged from any liability to any third party for acts of the firm done before his retirement by an agreement made by him with such third party and the partners of the reconstituted firm. Partners continue to be liable to third parties before retirement until public notice is given. Not liable if third party deals with firm without knowing that he was a partner. 3. Expulsion of a partner. If all these conditions are not present, the expulsion is not deemed to be in bona fide interest. 1. Power of expulsion must have existed in a contract between the partners. 2. The power has been exercised by a majority of the partners. And 3. It has been exercised in good faith. The test of good faith has required 3 things. 1. Exclusion must be in the interest of the partnership. 2. Partner to be expelled is served with a notice. 3. He is given an opportunity of being heard. If a partner is otherwise expelled, the expulsion is null and void. Note: expulsion doesn't result in dissolution of partnership. Neither invalid expulsion puts an end to the partnership. Even if it is partnership at will, it will be deemed to continue as before. 4. Insolvency of a partner. Where a partner in a firm is adjudicated as an insolvent, he ceases to be a partner on the date on which the order of adjudication is made, whether or not the firm is hereby dissolved. A state of a partner so adjudicated is not liable for any act of firm, and the firm is not liable for any act of the insolvent, done after the date of order of adjudication is made. Effects of insolvency. A. Insolvent partner cannot be continued as a partner. B. He will be ceased to be a partner from the date on which the order of adjudication is made. C. A state of insolvent partner is not liable for acts of the firm done after the date of order. D. Firm is also not liable for any act of the insolvent partner after the date of order. E. Ordinarily, insolvency of partner results in dissolution of firm, but the partners are competent to agree among themselves that the adjudication will not give rise to dissolution of firm. 5. Liability of estate of deceased partner. Ordinarily, the effect of the death of a partner is dissolution of the partnership, but partners are competent to agree that death of one will not have the effect of dissolving. Estate of the deceased partner may be absolved from liability for the future obligations of the firm. It is not necessary to give any notice either to the public or the persons having dealings with the firm. No public notice required in case of death. Rights of outgoing partner to carry on competing business. An outgoing partner may carry on business competing with that of the firm, and he may advertise such business, but subject to contract to the contrary, he may not A. Use the firm name, B. Represent himself as carrying on the business of the firm, or C. Solicit the customer of persons who were dealing with the firm before he ceased to be a partner. Agreement in restraint of trade is valid if reasonable to make an agreement with partners that on ceasing of partnership, he will not carry on any similar business within a specified period or within specified local limits. Rights of outgoing partner in certain cases to share subsequent profits. When a partner dies or otherwise cease to be partner, and the remaining partners continue the business using the firm's property without settling accounts with the outgoing partner or their estate, the outgoing partner or his estate is entitled to either A. share in the profits earned since their exit to the extent attributable to the use of their share in the property to himself or his representative, or B. interest at 6% per annum on the amount of their share in the firm's property. Revocation of continuing guarantee by change in firm. A continuing guarantee given to a firm or to third party in respect of the transaction of a firm is revoked as to future transactions from the date of any change in the constitution of the firm. In the absence of an agreement to the contrary.
If this helped you remember the provision, hit like, share it with your classmates who need it too, and subscribe. I'll upload